Good morning, everyone. We shall start our webinar now. To the audiences who have been here before, welcome back to our webinar. Whereas to the audiences who are new here, welcome to our webinar. My name is Leanne, and I'm IP Legal Executive at 𝐸𝐵. So to the audiences who are new here, let us give you a quick intro of our company. We are an IP boutique firm, and while taking care of your intellectual property, we intend to raise IP awareness among business communities. So if you have any ideas how to raise IP awareness among Malaysians or business communities, do share with us your ideas by dropping us WhatsApp or email anytime. So we hope that the sharing sessions today will help ease your registration process. And we will slip in a little bit pointers here and there so you know the pits and potholes to avoid when it comes to registering your trademark or naming your trademark. Here's the outline of the webinar. You can have a quick look at it. So this is what we will be covering today. And towards the end of the webinar, we will have Mr. Lawrence to share his thought and insight on post-registration issues. So moving to the first stop, what is a trademark? Trademark is an intangible asset. It is a property. It is an identity to your business, and it can add business value to your business as well. And these two symbols are the common symbols we'll see on the trademark. We have R symbols, meaning that the trademark is being registered, and also TM symbols, meaning that the trademark is still pending registration. So if your trademark is already registered, you may use the R symbol on your trademark. Otherwise, if your trademark is still pending registration, you should use the TM symbol. Because if you're using R symbol while your trademark is still pending registration, it is an offense under the law because you're actually falsely representing your trademark being registered. So there are many types of trademark that you can register. These are the common trademark that we have seen, the combination mark, the logo mark, the word mark, and under the new act, you can now register for trademarks such as hologram. We have motion here, and also sound. There are a lot of benefits if you were to have your trademark registered. You will have exclusive use of your trademark, and if you utilize your trademark properly, it will add business value. It will also expand your business opportunities. So if you're able to build an identity for your brand, you actually can license out your trademark. You can also earn royalties from licensing out your trademark to others. And other than that, if you have a registered trademark, you can actually take legal actions against bad faith competitors who might have been misusing your trademark all this while. So in other words, you're able to sue them for trademark infringement. So now you want to know who can register for a trademark. If you are an individual or an organization, you can register for a trademark. And if you are starting out, you're just starting out your business, you can have it registered under your personal name and then have it assigned to your company if you're thinking of expanding your business in the future. Other than that, trademark can be owned by multiple owners. So if you're thinking of setting up business with your friends, you can have it registered under your name and your friend's name. So your trademark will be co-owned by you and your friends. And now that you have an idea of how you want your trademark to look like or the name, you should know and you should evaluate the strength of your trademark. Ideally, we want a registrable trademark that can lessen the likelihood of it being opposed. So these are the characteristics of a registrable trademark. They are distinctive, they are non-descriptive, and they're not similar or identical to earlier mark. For example, it is perfectly fine if you want to name your trademark Apple if you're selling IT gadgets, but it is definitely not ideal if you want to name your trademark Apple if you're a fruit store owner because it is generic and you're actually referring to the businesses that you're doing. And other example would be beauty cosmetic. So if you are a cosmetic seller, you want to avoid trademarks such as beauty cosmetic because it refers to the product that you're selling. And now that you know the trademark that you want to have it registered and you figured out the applicant that you want your trademark to be registered under, The next thing you need to know is to identify the specifications of goods or services that you want your trademark to be protected under. There are 45 classifications for you to choose from, with Class 1 to Class 34 being goods and Class 35 to 45 for services. So specifications of goods and services would determine your scope of protections. For example, if you are a clothing store owner, other than to register your trademark under Class 25, you want to be specific. So if you are selling mostly baseball cap, you want to have that listed in your specifications of goods. However, you do not need to have your trademark limit to only one classification. So for example, if you're a cafe owner, we know that Class 43 is essential for you because it determines the services that you're providing. So you're providing a restaurant services. And second to that, you need items, you need goods in your cafe to help it run a business. So you want to consider Class 30, that includes coffee, dessert, beverages, and so on. So what if you expand your business in the future? Say you have developed your own mobile app, you are selling others' brands, coffee bean, and you have now providing your own delivery services. You want to expand your protections from Class 30 and 43 to Class 9, to Class 35, and to Class 39. We would encourage our clients to cover as much as they can because it actually determines your scope of protections and it also widens your scope of protections as well. So now that you have everything figured out, right before you submit the trademark applications, you should know the registration process. So you know what to anticipate throughout the registration process. A smooth trademark applications will take about 12 to 15 months until it is successfully registered. So a smooth registration process would mean that goes through examination stage, it goes through the publication stage without it being refused or being opposed. But we'll start with the very top, pre-filing searches and analysis. So we would advise our client to go through pre-filing searches and analysis because you'll then be given a search report from us and you're able to evaluate the chances of success of your trademark. And you'll also know beforehand that if there's any identical or similar trademark registered prior to you that will later block your application. So this pre-filing searches and analysis would actually save you money in a long run. And once you're confirmed that you want to proceed with the trademark applications, we will then send you a filing particulars. So filing particulars is a document that would include the details of your trademark, the applicant, company, and also a carefully drafted specifications of goods and services that reflect the nature of your business. And once we have your trademark application submitted, it will then go through examination stage, and then after that towards publication stage. So in the publication stage, your trademark will be published in 𝐈.𝐵𝐺 for a duration of 2 months. So if there's no oppositions in that period of time, your trademark will then be successfully registered. And once it's registered, what you need to do now is to apply for the issuance of the certificate. However, what if you encounter a little bit hiccup during the process? Do not be anxious and do not worry because you will have the opportunity to appeal. So if your trademark is being refused by the registrar, you'll be given this opportunity to respond to the office sections either by way of written submissions or appeal hearing. And the entire process will take about 1 to 3 years until the decision is concluded. And there's another possibility. So what if your trademark is accepted by the registrar, but then got opposed by the public? So this proceeding, the process is what we call a position proceeding. And if you look at the right side of the slide, these are the process of the position proceeding. A position proceeding is tedious. It involves a lot of exchanging of exhibits, evidence, and documents, and both parties will actually be given 2 months deadline to respond to each other. And other than that, they can also apply for a 6 month of extension of time. So if we do the math, it will actually take about 3 to 5 years until the decision is concluded. So what if you have already had your trademark registration registered in Malaysia? Please bear in mind that trademark protection, they are territorial-based. So a trademark registration in Malaysia does not mean that your trademark will be protected overseas. So if you want your trademark to be protected overseas, you have to apply for your trademark application overseas. And these are the two approaches that you can choose from. We have the first approach, which is direct filing. So direct filing is a traditional approach. And for this approach, you do not need to have any existing trademark application or registration in Malaysia. What you have to do is to appoint a foreign lawyer to help you with the trademark application overseas. The disadvantage of this direct filing is that it is much more expensive compared to Madrid system. Madrid system, it is relatively new in Malaysia. We just have it since year 2019. Madrid system is relatively cheaper. And for you to be able to use this Madrid system, you need to have basic application or basic registration in Malaysia. It is cheaper because one application can actually cover multiple countries. So say if you want to have your trademark registered in Indonesia, Thailand, or Singapore, you can have it filed in just one application. The disadvantage of this Madrid system is home attack. So it means that your trademark applications in Malaysia is being attacked. In other words, it's either being refused by the registrar or it's being opposed by the public. So that would mean that it would stop the trademark application process overseas as well. But to also bear in mind that even if you have had your trademark registered in Malaysia, each country still maintain its own discretions whether they want to grant you the trademark right or not. And if you're unsure which type of trademark approach, this traditional approach or Madrid system approach is suitable for you or which would benefit you the most, please do let us know. You can contact us anytime and we will advise you accordingly. Now we will proceed to post-registration issues. We will have Mr. Lawrence to share his insight with us. Thank you.
Thank you very much, Lian. Thank you for your sharing just now. Good morning, my name is Lawrence. How are you, everyone? Moving forward, I will actually share some points about what to do after your trademark has been registered. Technically, right, trademark protections is forever. But the thing is, we need to renew every 10 years. That is particularly in Malaysia. Most of the countries have the practice of renewing every 10 years as well. But some countries, they are still following the timeline of 7 years to 15 years, depending on the countries. But most of them are actually following the timeline of 10 years already. So it is a very long time period to observe. Sometimes you need to observe a lot of things after registration. Because registration of trademark, right, it doesn't mean that once you got it registered, means that we can leave it as it is. It doesn't work that way. There is a lot of things to be done after the registration. Yes, you get a certificate, but there is a lot of things you need to keep monitoring and then to keep your trademark active and valid, things like that. So I'm going to share after registration, what are the things that we should observe for your trademark. Of course, after my sharing sessions, feel free to ask anything. Actually, we allocated more of the time for all of you to ask questions. And then if you have any specific issue, we are actually more than happy to share with you what are the solutions or what is our view on your concerns, things like that. So the first thing is, after you got your trademark registered, right? Don't just put it there. There are many things to be done. The first thing is, make sure you keep using your trademark. It's not advisable to just register a trademark and then you are not using it at all and then probably just keep the certificate in the file. Because many countries, they have this particular law require you to continue using the trademark. For example, in Malaysia, your trademark is actually vulnerable for cancellation by others if you don't use it for 3 years, continuously 3 years. That's why some of the people out there, they have the idea of like, okay, maybe I can just log this name first and then I can keep it in my file and then I can use it whenever I want, or I can block others from using it even though I'm not using it. Actually, that is not so ideal because many countries, they have these laws that they require you to use the trademark even after registration. So if you don't use for more than 3 years, and somebody they found out and then they are interested in using your trademark, they might actually come and apply to cancel your trademark registration. In Malaysia, they have to do it through application with the court. So the best advice is once you have gotten your trademark registered, continue using it and keep using it. You don't have to use it to generate a lot of sales, even if the sales amount is not very high, but as long as you are generating sales, there are invoice, there are marketing activities going on, those are considered used already. So the next thing is, once you got your trademark registered, right, remember, you have to keep reviewing your registration. For example, just now the case point that the cafe scenario that Leon shared just now. Let's say I'm the cafe owner. When I first started my cafe, I started small because I'm an SME. So maybe I just start running my cafe, providing cafe services. I offer dine-in, and then everyone come in and then drink my coffee and then have my meal, things like that. At the beginning, I probably just registered for my cafe service. So I only do one registration. But throughout the years of development, I could probably expanded my goods and services. I add on my selling cakes, and then maybe I have my packaging. I start selling my products in the supermarkets. I start outsourcing to others. I can sell my products online. At this point, I will have to add on my registration and cover another class 30. And then sometimes, even if within the same class, right, your registration is actually restricted according to the list of products and services in your registration. For example, in my initial registration, I only state that I sell coffee. Maybe I didn't add the part that I'm selling noodle as well. I'm not saying that I'm selling cakes like that. So it is advisable you have to top up the products in your registration. And the top up have to be done by filing a fresh application. So you, from time to time, you will have to keep reviewing your registration. Let's say this year, next year, I plan to do expansion. I'm expanding my line of products and services. At that point of time, right, you will have to look back at your previous registration and then see whether those registrations could cover the new products and services that you are expanding or not. If they are not, then you will have to, probably you have to refile a new application so that you are covered. Because if you don't, right, if your competitor found out there is a loophole or somebody actually interested in your trademark, after that they found out your initial registration didn't cover that, right? Arguably, they might actually resubmit another application to cover the classes or the products that you didn't cover earlier. Of course, whether they can get it registered or not is another story. But to make things simple, if you have already logged in the registration at the first, you will actually reduce a lot of complication in the future. And then the next thing is, throughout the years of development, right, other than adding the new stream of products and services, expanding my business area, things like that, there is also possibilities that you are restructuring your business structure. Maybe you have gone through some M&A, you have acquired somebody's business, or you have been acquired by somebody. There might be some changes on the ownership of the initial trademark. So it is very important that you will need to update the ownership of the trademark in the registry so that it actually reflects the true ownership. Because there are many cases, right, we have come across where when they change ownership, right, they forgot about this part to change the ownership. And then by that time, they realize the need of doing this, right, it's probably a few years later, and they might have some change of directorships, or maybe the directors have migrated to other countries. Then the signing of the documents might get complicated. It's not that it cannot be done, but the process may get a bit tedious. So we would usually recommend that if there is any change of the ownership, let's say you have switched the ownership from A to B, or you are within the same company, you are changing the name of the company, we usually advise all these kind of identity issues to be updated promptly as soon as possible. Because when you need to use that, right, and when you realize that somebody is infringing your trademark, you will need to make sure that you are the correct owner, because you do not want to leave any loophole in your registration for the defendant to challenge your registration. So you need to show that you are the true owner through the registry. Otherwise, let's say we forgot to change the ownership, and then let's say you have changed from company A to company B, and then by the time you want to sue, and then the registry system should show that you are the trademark is owned by company A. Then, of course, when the defendant come out, they will say, hey, this trademark is under company A. You are not the true owner. So it will actually leave your case quite challengeable, arguable, things like that. Of course, there are many ways that we can still rectify at that point of time. But of course, we also want to make sure the entire process is smooth so that less hiccup when we want to take legal action in the future. So this part, you need to, so to sum up, during this reviewing process, you need to make sure your products and services are always well covered, and then the name of the owner are always updated. Okay, so I'm moving on to another slide. Renewal is pretty straightforward, particularly in Malaysia. We just need to renew every 10 years. But some countries, right, they have the requirements of asking you to file the evidence of use. They will ask you to file declaration of use in order to keep the trademark alive before even you can file the renewal. For example, US, every 5 years, you will have to file a declaration of use. And Philippines, they will also, after registration, they will ask you to file another declaration of use. All these deadlines are very important so that you can monitor and then keep your evidence of use in the file. So when you need to file all these declarations, you don't have to go through the hassle of digging out the files again. So from time to time, keep your latest product photos in place, keep them in the file and in one place, your invoices, your sales records. And when you are ready to, we call this maintenance. Sometimes there are a lot of things to be done during your maintenance. In some countries, they will even ask you to pay some tax. Like South Americans, there are some countries, right? They will ask us to pay some levy in order to keep the trademark alive, things like that. But not all countries. That is actually quite a rare scenario. So make sure you remember to renew your trademarks from time to time when the due date is approaching. Okay, the next thing is about the licensing and franchising. Actually, many of us have misunderstood that the registration of trademark is just for the purpose of stopping others from using my trademark. I just want to protect my trademark. That is actually just the very beginning purpose of registering a trademark. A trademark is a form of intellectual property. You can actually use it to generate a new stream of revenue. And there are two ways of doing it. You can call it either a licensing or franchising. Actually, franchising and licensing, they are different things, but they have a lot of overlapping. So the most common similarities they have is actually you are giving others the right to use your trademark. For example, licensing is more straightforward. You just need to give others the right to use your trademark, and then you collect X amount of royalty out of it over a certain period of time. But for franchising, it will be more complicated. You can't sell a franchise without registration of franchise. We have to always remember that. So first thing, franchise board would actually require us to register your trademark first, or even show them your registration document, your filing documents, because they do understand that registration of trademark takes time. So sometimes they will just require you to show them your filing documents. The difference between licensing and franchising is licensing is a bit more casual. You just need a piece of licensing agreement, give the other side the rights to use your trademarks, and then you collect X amount of royalties. But franchising, you are actually giving out the entire business model, and you have to do your franchise registration first before you can start recruiting a franchisee. These two are the main difference. Franchising requires registration, licensing is not required registration of franchise. But one thing is, even though licensing is sounded like you do not need to register for franchise and there are less formalities to be complied, but usually we would advise our clients to carefully choose your licensee. We call it licensee because you need to make sure that they also protect your brand identity as well. In your licensing agreement or your franchising agreements, right, it doesn't just say that how much royalty you are collecting, how long they can use, things like that. You should also include a lot of conditions so that you can control your licensee or franchising to ensure that your brand identity, the quality of your brand, your reputations are protected. They better follow your way of advertising, your way of marketing as well. Some of our clients, right, they have the higher standards. They will say, before you start marketing, you better get my approval or send to the franchisor or licensor to review first. In future, we will also have another webinars to discuss in detail about licensing and franchising. But today, what I'm sharing to you is actually there is a way for you to generate additional stream of revenue by way of licensing and franchising. Just the difference between them is one is more relaxed way, informal way, but it's still bound by agreements. Franchising, there are more formalities to be compliant. Okay, I'm moving on to the next slide. which is on the sale of trademark. Trademark actually, other than franchising, is a form of asset. You can actually sell it to somebody else if you want to. But of course, the value is a buyer and seller willings. There are some ways to calculate the value, but actually you can sell your trademark to somebody. And then if they're willing to buy, you can actually sell it at X amount of money and generate a lump sum income for your company. It can be done by way of assignment. The process is not so difficult. Both parties will just need to sign the deed of assignments, and then together with some formality documents, then the transfer can be done really. So, yeah. Let me see if anything I have not covered. So the last thing is I'm going to share with you is this is the statistics that we have just for some comparisons. This is the numbers of the trademark applications that we can see among these 5 countries, these 4 countries and European unions. These are the number of new trademark applications being filed every year. Not to say that they are all registered trademark, but I'm saying that new trademark being filed. So we can see that Malaysia every year we still have about 40,000 new trademark being filed. They are processing 40,000, which is why I kind of explain why trademark it still take time. Some countries, it will take shorter period of time. Malaysia generally it takes about 1 year plus. But this one is not a big concern because the registration, the protection period actually starts from the date of filing. Even though some of the registration process, it will take longer. We have handled quite a few, it will take about 5 to 6 years due to multiple proceedings in the middle of the process. For example, they have objections from the registry, they have oppositions from the public. So those registrations are taking longer time, but I wouldn't say all applications encounter that. Most of the smooth applications, right, usually about 1 year plus, they will get it registered already. But don't worry about that. The protection period actually starts from the date of filing. So for example, I filed an application today, and then I only got my registration done by end of 2023. Then my protection period actually starts from today, upon registration. So yeah, these are the rest of the countries. Singapore, they have about 78,000. China, the number is quite encouraging. Every year, their number of applications is increasing. Now they have 10 million a year. So yeah, that's my sharing for today. Thank you very much, everyone. I think we can start the Q&A for now. May I know if any one of you have any questions? We are here to solve your trademark concerns.
Good morning.
Good morning.
My name is Mark.
Hi, Mark. Good morning.
Yes. Okay. Actually, I got to know about the IP agency through Miss Ong Wei Jun. Is she around? I suppose.
She's here. She's here.
Okay. Good. I got to. I'm actually an individual member of 𝐂𝐚𝐧 Chinese Chamber of Commerce industry.
Okay. Yeah.
So and I got to know, I asked for a quotation last time, okay, but I wasn't ready to proceed yet. I think I'm in a situation whereby I'm interested to proceed in respect of having trademark protection on my site. I'm actually the principal of Mark Academy, MAK Academy.
Yeah.
So basically what I've done is that in August 2019,
Yeah.
I personally went over to my IPO office in order to register my trademark and submitted the TM5 document. Okay. Okay, so that's what I've done, and I paid my fees already to my IPO 370.
Alright.
So as you mentioned that the protection starts at the point of time where registration begins. But here's the interesting thing. I'm going to be changing my address next month.
Yeah.
Okay, I'm going to be changing to a new venue.
Okay.
The registration is actually done in my business, in the case of my business, okay, which is Mark Academy itself, is a sole proprietorship. I know that sole proprietorship is actually directly related to because it's like sole proprietorship is like a personal business, so I suppose it's directly linked to me as a person, okay. But the thing is, in the future, I plan to establish a company. So Yes, as 𝐶𝐴𝐵𝐴 Berhad. Yes,
Okay.
that's right.
Yeah.
Here's the thing. Does it make sense for me? I mean, as the personally is the ownership is in me. Okay, I mean I'm holding personal ownership of my trademark. Does it make sense for me to actually make it transfer ownership to my company, even though I will have shares in it, or should I hold it personally? Because this has a lot to do with I would say it has a lot of personal value in my case. Okay, so how should I make a decision in respect of it being personal or it being under a 𝐶𝐴𝐵𝐴 Berhad?
Okay, to answer your questions, yeah. Okay, one by one. Just to highlight to you, yeah, because your trademark was filed in August 2019, and I
Yes.
noticed that you filed under the form TM5. So your application is actually filed under the old law. In December 2019, right, we have the new act came in already. So for your applications, it will be examined under the old law. And then now the fees has changed already quite significantly, the filing fees at the MyIPO sites. That one is one thing. The other thing is, okay, in your situations, right, both are actually doable, legally doable. Let's clear out the procedures and the legal part first. If you want to maintain the ownership under your personal capacity, and then and yet you want to establish your 𝐶𝐴𝐵𝐴 Berhad, this is A, option A, is doable. Okay. B is you are going to transfer the ownership from your personal capacity to your company. All right. So let's make it clear, both are actually doable. And from the trademark registration perspective and then recorder of change of ownership perspective, these two are actually doable. And why you are choosing A or B is actually for the purpose of registration or the MyIPO purpose is not quite relevant. So now down to your questions of whether you should choose A or B, whether you want to keep under your personal capacities or your under your companies. Under usual circumstances, right, unless there is a specific reason for not doing so, we would still advise you to transfer the ownership to your company. That's under usual circumstances, but unless you have other specific issues, because may I know your new companies, do you have others shareholders or it's just yourself?
Just myself.
Just yourself, right? Okay. If it's just yourself, at this point of time, when the company is only yourself, right, the effect is not so significant yet. You can still own by under your personal or your company. Because if you have other shareholders in your new companies already, right, who are actually your partners at arm's length, right? They might not be your family's members or there could be some other business partners, right? By that point of time, they might have some questions of why you are still owning the trademark under your own capacities instead of putting it in company, because they might be more comfortable on the company owning a trademark. Because in somehow the trademark can be the company's asset, and when the trademark is quite reputable already, other shareholders may require the trademark to be owned by the company, because from their perspective, they think that is actually more fair. But if both is under your own personal capacities, right, at the beginnings, you can still own under your personal capacities. Because why I say both are actually doable, because there are some situations, right, they are actually owned by the company, the person. In your situations, like they own by the individual capacity, and then they will still license it to the company to use the trademark, and then they will charge X amount of royalties from the company, and then the personal get his personal income as well. That's why I said legally these two are doable, but you will have to evaluate the need of doing it. Is there any reason why you want to keep under personal capacity, or is there any other reason that you want to keep under company capacity?
I'm trying to say this is like this is when I established my academy is with the rationale of not just about teaching. Okay, it's not just about contributing to society through education, but also because that's my surname. This is my surname. And is a reflection of my family heritage. You see, so that's why it is something whereby is I think that's where the personal sentiment comes from. Okay, whereby it's really about family. It's about family. So I would say, because there is a personal value behind it. So in my case, I would say I wouldn't want to have it leave it in a position whereby the surname is there and then it's in the company, and yet at the same time it can be tarnished by external parties beyond beyond control. See, so I suppose that would make sense in respect of why I would want to maintain personal control of the logo itself, because it's more than just a logo or trademark or for business or licensing or whatsoever. It's really about honoring one's ancestors, coming from an Asian traditional point of view.
Understand. That is actually understandable. It's doable. So if you would like to maintain that arrangement, right? And then once you got your trademark registered, there is one thing that additional step that you need to do is in the 𝐸𝐸, you will have to, we just need to draft a simple license letter or license agreement between you and the company. And then you register your company as a registered user with the 𝐸𝐸. So, because one of the things important during infringement, let's say you want to sue somebody for using your trademarks, right? Two things you will need to prove. One is that you are the owner of the trademark, and then you are maintaining the reputations of the trademark. Because we don't want them to challenge in future to say that, hey, you are owning the trademark under A, but you are using the trademark under B. So you need to establish the tie between two of you. So in order to if you plan to do that, you therefore for all your intentions, just you mentioned just now, to actually fulfill and then to safeguard yourself, right? I think you can do that, but remember to do one thing: you will have to register your company as a registered user with the 𝐸𝐸.
Currently, my trademark, my logo is registered under my sole proprietorship mark Academy. So in the future, if let's say I want to put it in my personal capacity, it can be done. It can be, the conversion can be done from my sole proprietorship to myself in my own name, in my personal capacity.
Yes, can. We just need to do some changes on the record. Technically, right, I would say that when you register under sole proprietorship, right, it's already yours already. Because sole proprietorship and individual, they are not separate entities.
Yes, that's right.
Yes, so in somehow you already registered under your personal capacity, but to update the record later, you can still change the records over there.
Okay, noted.
Yeah.
Okay, Ken, I'll definitely be keen to catch up. I'll leave my contact information, and then I'll actually Miss Wei Jun actually has my contact information. So I have my document in respect of the registration. I spent 370 ringgit last in 2019.
Yes.
So I will definitely love to follow up and catch up. And
what's the status of your application?
Okay, after sending my application on the which was accepted on the 8th of August 2019, no reply from my IPO. Zilch, nothing. No dispute, no whatever, just nothing.
Okay. What happened to you is actually not is not something unusual. I will suggest you later because here is still a public forum. I won't recommend you to review any more details here. Later, you can send Wei Jun your application documents. Let us check the status for you, so that we will know what's the situation there. Because honestly speaking, sometimes they might be a little bit slow, but I would say that you should have gotten some response by now already. You should have gotten some response by now, so we better check now. It's time to check, because despite some delay due to the MCO or some the trademark office last times, right? But usually within 1 year, we should have gotten something already. So I suggest you later you send the application detail to us. This one we can check for free for you. Don't worry. So
maybe I can just drop by at your office. I suppose it should be okay.
Can. So because under normal circumstances, the registry send out documents by normal post. So it's not unusual that the documents or the letters was actually lost in transit. you might not receive it. They might have sent out to you, but you didn't receive it. They send by normal post, right? So sometimes the sending process is not so smooth. It might lost in transit, things like that. It happens. So I think we can check on that.
All right, can.
Yeah.
Okay, appreciate it.
Yeah. Any more questions? Everyone else? Please feel free to ask. It was a very good sharing from Mr. Mark just now. That is actually quite a common situation faced by trademark applicants in Malaysia, where we filed the applications and then they didn't know what happened. Actually, many of them have misunderstood, right? The moment they submitted, they thought the application, the registration is done. And then they thought, hey, how come just a few days only, why you all say it about 1 year plus like that? Because they misunderstood. They thought that the filings means already registered. No, they actually need some examination, which usually takes about 1 year. It could be shorter, but so far we have seen, right, at least take about 8 to 9 months. Yeah. Any more questions? Everyone else?
Yeah, yes, Gayit here.
Hi, Gayit.
Yeah, I just wonder, after the new act being imposed in end of 2019,
All right.
did you come across a lot of application received provisional refusal? Compared to before?
No, it happens, but I wouldn't say it's actually more than before. I would say the ratio is still normal because they actually, I would say it's not safe to compare the success rate based on the percentage because many times you still have to go back to the nature of the trademark.
Yeah, okay.
We have to go back to see the nature of the trademark. Sometimes, right, some of the clients, we have encountered some of the clients, right, they have done some registration before, and then they use back the old method to register under the new act. Actually, the new act has changed a bit, which is why I think it actually causing you what you said just now. It seems like a lot of refusal coming up after the new act. But there are some things that we need to be aware during the new act. One of the common things that we have to be careful is the disclaimer. Under the old act, right, when we filed something without a disclaimer clause, the registry would act for us during the acceptance. But now under the new act, right, some of the examiner, they might actually just refuse the application and then ask you to disclaim at the beginning.
Okay.
So there is a switch of practice, but it really depends from case-to-case basis. So I wouldn't say it's because of the new act, it causing more refusal. At the end of the day, we still have to look back what is the trademark itself.
Okay.
Yes.
So actually, for my case, my company logo, we submitted an application in October of October 2020.
Okay.
And then my company logo is a combined logo, means that it's a logo design with the alphabet name of the company.
Okay.
And then we received a provisional refusal.
Okay.
Because my company name is Legenda Properties. Legenda is spelling as LAGENDA.
Okay.
But the refusal reason is because there is another register, which is Legenda, without any logo, but registered, just Legenda, LENDE, accordingly. So I was wondering, is this common as a reason to refuse?
Yes.
Even mine is combined.
Yes, correct. It's quite common. For this particular scenario is quite common. So one thing is because of the name. The name is quite similar from their point of view. They are thinking that the pronunciation is quite close, so that they will, even though it's combined, but because the pronunciation is still there.
But if like this, my appeal, the chance will be high or low?
Okay, for that one, we will have to look at the other side's trademarks details, because when comparing a trademarks, right, we are not just comparing the name of the logo or the appearance of the marks. There are other things that we can consider as well. For example, the other sites, there are lists of products and services, and then there's registration status, and then your length of use, your evidence of use, things like that. Actually, we can find that a lot of trademarks in the registries, right, their name are the same one, but both can be registered, because the thing is because their business are different. Their business are different.
Mm-hmm.
If you notice, right, we have a few trademarks that the name are the same, but the business are different one. For example, if you notice, we have, do you realize that we have two types of magnums? One is selling ice cream, the other one is selling body.
Yeah, correct.
Yeah. So at the end of the day, we will still have to evaluate the other side registration and compare with yours. Then only we can evaluate the chances of success.
Mm-hmm.
But honestly speaking, if the other side are also in exactly the same line of business as you, right, then the chances is not, I would say, is quite challenging.
I see.
Yes,
yeah,
yes.
Actually, for your information, it's same sector. Exactly same sector.
I see. Yeah. Then we that is quite a challenging refusal to appeal. But we will have to go through your evidence. See during your evidence, is there any things that we can still argue against a refusal?
Such as?
Your length of use, and then see if there is any other things you can distinguish yourself from them, things like that. We have to argue from the point of your entire business as a whole. But because the name are so familiar, right? Sometimes even if you're adding on a logo, it is still not helping much as well.
I see.
Yes.
Okay.
Yes.
So the only thing is to prove that my company is slightly different from them, even though in the
not slightly, you have to be distinguishable different.
Distinguishable. Okay.
It has to be because you see, one thing about examining two trademarks, right? They have to distinguish these two trademarks. They are not confusing against each other. And whether confusing or not, it's actually not my say and not even your say. They are actually considering from the point of the consumer or the public. Yes. So we will have to tell them, you see, the public won't be confused with these two trademarks. Yeah. So we will have to evaluate your entire business models, and then we see what kind of evidence you have, how long you have been using it, things like that. But based on what you shared with me just now, it's quite a challenging matter to do. But we will suggest you to have a separate consultation with us so that we can meet up and then see anything we can do. Just to let you know, when is the deadline? When did they issue the letter to you?
I know the deadline. We actually submit in an appeal already. Just that.
Okay.
Yeah.
Okay. Good.
Thank you so much for
Okay. No problem.
So I will look for Wei-Jun if I need any assistance on this.
Sure. Please do.
Thank you.
Thank you.
Bye.
Yeah. Any more questions? Please feel free to ask. But I would like to add, right? Refusal is not something too scary. I wouldn't say it happened very often, but I would say that it's not something uncommon to happen, because when they have a refusal, it doesn't mean that it's end of your registration process. You will be given an opportunity to answer to their refusal. Sometimes they just ask for clarifications or maybe ask you to amend your registration. Thank you very much, everyone. That comes to the end of our sharing. Thank you, Gai. Yes?
Lawrence, yes, something came to mind. I have a friend, okay?
Yeah.
She is a digital marketing trainer, okay?
Yeah.
And I really advise her to be connected with your company, okay?
Thank you very much. Thank you.
Okay, now here's the thing. She shared with me something which is she has done. I mean, as educators, we do things like writing articles, on our blogs. We do videos, instructional videos, things like that. Okay. She shared with me an interesting case whereby she had a student downloaded her videos. The student downloaded the trainer's videos. Okay. And decided I think that did funny things with it, like maybe I don't know what exactly happened. I would guess that not only downloaded the videos, but also probably put up on her website. Okay. She has yet to register. I don't think she has registered her trademarks or copyright, but she has already done these works. Okay. So I would imagine that she will need professional help in this respect, in order to be able to address this conflict, this abuse of her creative work. Okay. But what I want to ask is this: as a trainer, as an educator, I produce work, I write, I do content marketing stuff. Okay, I do things on blogs, on my Facebook and things like that. And at the same time, is like video is prevalent. So here's the thing. What should we do in principle? What should we do to protect the copyright of our work? And as it is, we are churning work left, right, and center. So it's nice to say we should copyright everything that we do, okay? But I think that is also going to be super costly, because it's like it takes a lot of effort in order to
Correct.
create content,
Yes.
put it up, market it, and somehow I don't know, does it make sense to actually copyright everything? So I think so this is the situation where as educators, we want to protect our work. We don't want people to just anyhow steal it. But at the same time, we need to have a balance in respect of cost and benefit in this respect.
Yes. Yes.
I could use your take in this respect.
Yes. Yes. Okay. Let's clarify first. Just now you actually covered the issues of trademarks and copyrights. Yeah, there is a difference between these two. In order to protect your trademark, you will definitely need to register it. That is your logo, your names, things like that. But copyright, no. You don't have to register your copyright in order to get protections. Protections on copyright is actually automatic the moment you have completed the video, the moment you have completed your write-up, okay? Then the moment you publish it on the internet, then you will have the automatic protection recognized by the law. So under the copyright laws, right? Last time, a few years back, the government actually amended the law, making it optional for you to register your copyright. Last time, the principle is still the same. Until now, still the same. The copyright is protected upon you finish the work, and then after that, you publish it. You automatically entitled already. But now they have added one more additional step. You can register, okay? But even if you don't register, your copyright is still protected. The reason why they come up with these additional steps, right? Because due to this automatic principle, many owners, when they want to sue somebody, they short of documentation proof. So they came up with this registration process to actually give you an official proof that you are the owner of these copyrights. So down to your question just now, since you have already published all the work, you have written all the works on the internet, things like that, right? Then at that point of time, you are already automatically protected. And then in order to do that, right, you can actually, based on that, you can straight away sue the infringers, or you can even send them a warning letters, ask them to stop reproducing. But sometimes you have to see what is the purpose of them downloading. Honestly speaking, if they are downloading just for their own private and domestic use, right, somehow you have not caused any economic damage to you. So you will have to consider whether you really want to take actions against them or not. But if they are actually downloading and then reproduce on their own website and then for their own commercial use, right, this is something that you should get serious and then really consider about taking a legal actions. And then on the practical side, right, remember always put a copyright notice on your work. And then you just now you mentioned about videos, right? Put a watermark that is quite difficult for them to remove when they are re-uploading on their own website, things like that. So that they won't be able to, even if they copy and upload it, right? Somehow your watermark is still there. So that if you want to take actions against them, it's a good evidence. Because sometimes when they download and put on their site, right, they might argue that, oh no, this is my own creation. I have actually improvised here and there, things like that. So put your own watermark. Okay, you mine something there so that it can be your evidence. And then the other thing is when you upload it to the public domain, put a proper record. When did you complete the work, finish writing the work? And then when did you upload? All these are served as an evidence. Because the date of completion and also the date of publication is an important proof when you are taking actions against a copyright infringer.
Okay, so normally what I do is I have my own base documents, which is, let's say, before having a website or before I put out a blog article. Okay, let's start with website. Website normally is I will build my own institution profile document with in a Word document. So that is the original source of work before it moved to the website. That is considered strong documentary evidence.
Yes.
Okay,
those are helpful.
Then the next. Okay, then the next thing would be, of course, let's say if I were to publish blog articles, normally is I will write an original article using Word, then after that put it up onto into my blog, but I will do optimizations. So there will be some alterations to make sure that it's in compliance with digital marketing. Both of this will actually be sufficient as well. Can I safely say that?
Correct. Yes, because somehow the essential requirements is you will need some evidence to prove when did you first created the work, and then when did you start publishing the work. Other than registration, honestly speaking, registration of IPs, right, is just the first step of securing your rights. When you go to the stage of you want to sue somebody, right, the most important thing is evidence.
Okay. Where evidence is concerned, I think I can understand it. So if there comes a time where litigation is necessary, if anybody is abusing our copyright or trademark, you guys also can do this?
Our firm can't do this. We are not advocates and solicitors. We are actually registered IP agents. So we usually...
So
you need to find
yes,
you need a solicitors. You need an advocate and solicitor to take legal actions. But of course, we can refer our associates to you if necessary. But at that point of time,
in your professional opinion, do you think would a normal advocate solicitor be able to handle something like this, or somebody who is specialized in copyrights and trademarks, intellectual property, will be better suited to handle stuff like this?
It will be better for those advocates and solicitors who have handled IP cases before.
That would be better because they have more experience as well.
Correct. They know how to strategize things at the beginning. What are the things to do and don'ts?
Okay, noted.
Yes. Yeah.
Okay, thanks.
Yeah. Okay. Thanks, Mr. Mark. It was a very good question. Okay. Anyone? Any more questions? If there is no further questions, please, everyone, we would like to invite you to give us your comments. We hope that we can improve better next time. What are the contents we should share, or our manner of conducting the sessions, whether it's helpful for you or not. Our primary reason is to help you understand the process better. And then if there is anything that we can help you to make your decision on strategize your trademark registration, that's the most important. So if anything we could help you to understand more, please let us know through this feedback form. Thank you, Mr. Mark. Thank you. We'll be doing it very often. Next time, we'll be covering more topics on IP, not necessarily on trademarks, but we will also cover things like patents. We will cover things like designs, copyrights, and we will slowly roll out other languages as well. BM version, Chinese version are all coming up. So if anything that you would like us to share, please do let us know. I'm going to end the sessions for today. Thank you very much. We will let you know I think in the next 1 or 2 months, we will have another sessions on other topics. So we will be sending you the invitations very soon. I would like to thank every one of you for joining us this morning. Thank you very much. Have a good day. Stay safe, everyone. Thank you very much.